Hello, Tech Pros, episode 181.
Pick up the phone and speak to your IP attorney, because that's what we're here for. We're here to just hear about your business and talk about it and just see if what you're doing is in the best interest of your business.
Welcome to the podcast where I chat with professionals who are getting the job done using technology 7 days a week. Each week we start with Motivation Monday. Tuesday is about productivity, Wednesday, leadership, Thursday, technology, Friday, people and communication, Saturday, entrepreneurship, and Sunday, being unplugged. All right, let's get started. Hello, Tech Pros. This is Chad Bostic, and I'm excited to introduce our featured guest today, Anthony M. Verna III. Happy Saturday, Anthony.
Well, thank you for being so formal, Chad. Everybody's working for the weekend.
That's right, absolutely. But are you ready to hustle this entrepreneurship Saturday?
Well, who isn't?
Absolutely.
You have to be. If you have your own business, you always have to be hustling.
Every day. Sometimes it's on Saturday, and sometimes it's just every single day that ends in Y. I mean, Anthony,
you don't want to know what I was doing this past Sunday, man. I was I was typing away, working.
Oh, man. Well, see, we're going to have to bring you back on a Sunday being unplugged, which is all about work-life balance. And you and I can both talk on Sunday about how we would like to be unplugged and how we would like to have some downtime away from the keyboard. But I struggle that so bad. But anyway, for the guests out there, Anthony M. Verna III, if I can be very, very formal for just a moment, is the managing partner at Verna Law PC. Anthony has a bachelor's degree in computer science from Case Western Reserve and his JD from Rutgers Law School. Not only practicing at his own firm, Anthony has led multiple continuing education classes and professional development seminars, including practicing before the Trademark Trial and Appeal Board at lawline.com. Which, Anthony, I'm sure there's going to be like thousands and thousands of listeners out there right now that are like, I got to go sign up for that seminar. Practicing before the Trademark Trial and Appeal Board sounds like something that's, I need to invest my entrepreneurship Saturday in watching that course.
Well, I hope that nobody winds up in the Trademark Trial and Appeal Board. I certainly hope that you're more of a let me say this. I hope you're more of a branding superhero than that. I can certainly talk about how not to wind up in the board while I'm with you. But if you're curious, it's over on lawline.com, and you'll just have to search for that particular phrase, and you'll find it.
Awesome. We will check it out. Hopefully we don't ever end up there. But, I got this question is, you went to school for computer science. Was your intent to take that and then turn it into a law degree and become a computer science lawyer person? Or
No.
was your intent to become a software developer and it led you down a different area?
Yeah, actually, I originally started with a double major. Meaning I got no sleep because it was computer science and music. And at somewhere after my freshman year, maybe in my sophomore year, I changed music to a minor because my grand design was to figure some way of melding programming and music, and it just wasn't happening in college. So I bumped music down to a minor, stuck with the computer science, and about a year into programming, coding just wasn't necessarily my personality. Mm-hmm. And I still have lots of friends from college who are still coding. I have lots of friends from college who are still engineers. I seem to be the only weirdo who took a left turn into a different career after getting an engineering degree, at least from my college friends. And personality-wise, it just wasn't for me. And what I like about my law practice is that I still have the esotericness in my area of law that I did as a programmer. And I'm a lot more hands-on with the people who are behind the businesses. And when I was programming, I felt a little too lonely. Even when I was in a team, in my, I had two programming jobs after college. Even when I was in a team, I just felt a little too lonely, and it's just not really my personality. Even now, as as a small attorney, I don't actually feel lonely because I'm always speaking with my clients. And some of my clients have turned into really good friends. And some friends have turned into clients as well. So I just think personality-wise, it wasn't for me.
Dude, I completely understand. I was drawn to computer science, first of all, because when I was a kid, it was really, really fun to invent new things that nobody else had seen before, or to take games, the source code for games, and hack them and make new levels, or make levels that were harder or something like that. But then once I got into the industry of computer science, software development, it was really fun doing the same stuff but getting paid for it. But I feel you on the loneliness. So I've always, my entire life, struggled with social anxiety, and I think I put myself into this position to get paid for writing code, number one, because it was fun and it was something that I was doing for a hobby. But number two, it was a position where I didn't necessarily have to talk to people very much. And as long as I knew what the requirements were, then I could spend weeks, literally weeks on end, not talking to anyone and just putting my headphones on and doing my thing. But that's why I'm in a podcasting position today. And that's why I got into IT management before, is because I wanted to push myself outside of those boundaries to kind of recover from some of my social anxiety problems and to really grow as a person and an individual. Still love software development from that, like you said, that esoteric position of we're doing really awesome, neat stuff that it's kind of like being a wizard, right? Nobody really understands exactly what you're talking about, but the other wizards do, right? So that's fun. But enough about me. Let's talk about you and your practice, man. So you're helping people with this combination, right? So branding and computer science and all the other stuff that's going out there. I mean, right before the call, we were talking about how, like, I sign up for a EULAs and I just go next, yes, accept, whatever. I just want to use the software. I don't really care what all the legalese is until I get to the position where I really care what the legalese is. And so maybe you could kind of walk us through some of the rights and wrongs and indifferences and stuff that we should be looking out for in our entrepreneur practices.
Sure. So my practice is trademark, copyright law, general soft, what we would call soft intellectual property. And that would just mean anything except patents. I do actually have a patent agent as well. So you can come to me now with any patent questions, and Will, my patent agent, and I will team up. And then I also do advertising law. And end user license agreements is somewhere in between intellectual property and advertising law, because it's a contract, effectively. And whether you're a user or whether you're a developer, you need to look at that particular end user license agreement and understand that that is a binding contract. And the way it is written is the way it will be enforced if you need to go to court over it. And some provisions in there might seem a little harsh, like not making a copy. Well, copyright law says I bought this copy and I can make it. That's correct. But the end user license agreement, if it says you are not allowed to make a copy, even a backup copy, that would override the copyright law. So you need to think about those particular issues, whether you're a developer or end user, when you're drafting or reading an end user license agreement. In a more general sense, I would say a lot of businesses do fail to properly do their due diligence on their brands. When a client comes to me with a new trademark, I say we have to do a trademark search. I have to get raw data. I have to write an opinion letter, and I have to tell you what not just what your chances are of registering it, but what your chances are of being sued by using it. Because my first philosophical goal is that I'm helping my client protect his or her business. And that's the key. It's the business. And in filing a trademark application, you could be sued for doing that. And that sounds harsh, but I would say 85% of my practice are people who are former DIYers who now we either have to defend a trademark or we have to change. And so step one is, for me, just making sure that all of the branding is vetted properly. And that is that to me is the biggest goal of my practice. On the copyright side of life, a lot of businesses are generating content, whether that content is on a website, whether that content is on some other site. The idea is that the business needs to be the owner of that particular content. And do you have the right agreements in place in order to make that happen? If you're using a company that helps you with content creation under copyright law, if there's multiple authors, there are going to be multiple owners. So you have to have an agreement that irons out. Might be a work made for hire agreement, as we call it, which means that this third-party independent contractor has no rights. And that's the way it should be. But you have to make sure that all of that belongs to the company, because regardless of what I do, I'm helping a company, and it doesn't matter what the size is, but the entrepreneurs are the ones who forget this. Right. All of this are assets that belong to the company. And those assets should be laid out on your balance sheet when you talk to your CPA. We own all of these copyrights. We own 3 trademark registrations, whatever it is. We've got 10 domain names. We've got 150 domain names if you're being ridiculous. But there are all of those have some kind of value, because that is what our companies are based off of today. So the value of that has to be determined by some kind of formulation. And part of that is protecting it with the laws that exist.
Gotcha. This is very enlightening and also very, very scary, right? Being one of these people that is a DIYer.
Not out to scare you.
No. It's just that the potential for bad things to happen are there, right? And we want to protect ourselves. But also, if we're in this position where we're bootstrapping everything and we don't have angel investors coming in saying, here's a bucket full of cash, go spend it on protecting yourself, then you're just like, okay, I'm doing it. I've got my 9-to-5 job and I'm going to do this. I'm going to buy a domain name. Hey, the name I want is available at GoDaddy, or the name I want is not available at GoDaddy. And so I'm going to get something else. And so if that something or other.com is available, then okay, that's my brand and that's where I'm going to start. And then whether it's a blog or it's a website or it's a, podcast or whatever it is, everything kind of stems from that whatever domain name that you're able to secure. But it sounds like it's more than just the domain name. Like there's other trademarks that need to be taken into account. So at what point in our DIY do we need to spend the money and the time to kind of do this intellectual property search, this trademark search, to make sure that either we're not going to get sued in the future, or if we grow our business, that we're going to be able to secure that property, so that we can protect ourselves?
The most desirable answer, Chad, is at the very beginning. Now, I realize that for a lot of small businesses, that's not always possible. Which is why I keep my process intact, regardless of whether my client is a startup or somebody or a business that's still struggling to go on, or a business that's been an ongoing concern for 10 years. The beginning is when you should worry about it, but I realize that not everybody can. Let me tell you a story. I have a client that came referred to me from my wife. So always a good referral. People
Yep.
that know your wife.
Absolutely.
And I sat down with them in 2015, early 2015. And I said, well, you've got a brand for X and you've got a brand for Y, and your company name's a brand as well. And you really should invest the money for doing a trademark search on everything. And I said, and I realize it's not, cheap, but at the very least, at your company name, at the very least. And the reason for that is everything that this company was using, it was a brand. The company name was a brand. It's kind of like when you buy a Pepperidge Farm box of cookies and you look on the back and Pepperidge Farm is there, and then they've got 16 different types of cookies, in the box. It's the same analogy. The business name is a trademark, and each of those different flavors is a trademark as well, because they all relate to the different quality of that particular cookie. Even if, like, if you file a trademark application and you just say cookies, you're not going to say chocolate chip cookies or oatmeal cookies. You're just going to say cookies.
Right.
Regardless, each of those is a brand and each of those is a trademark. And so this company was acting in a very similar fashion. And the business owner's like, well, can we wait until we have better cash flow? And I said, of course you can wait until you have better cash flow. Understand, the sooner you act, the easier life is. And the longer you wait, the longer you let other people in. Mm-hmm. And I hate being prescient, but about a year later, they sent me an emergency email because a company that we'll call it a competitor filed a trademark for a very similar trademark, if not exactly the same as their company name, in their goods and services. So now you're going to have a conflict, because while company A has been using the trademark longer than company B filed first, which means you actually have to knock them out of their trademark application. That means going to the Trademark Trial and Appeal Board, which is a federal administrative court, and getting that judgment. And so that's now you're talking lawsuit instead of just a trademark application.
So you're talking more money, basically.
So more money, more time, more headache, more heartache. So I'll always say, the sooner that you are able to do it, the better. The other option there is always changing the trademark, and of course that comes with its own heartaches as well, to rebrand a company. Mm-hmm. So the sooner, the better that a company can talk to an IP attorney and iron out those particular issues.
Gotcha. Okay, so we want to do it as soon as possible, but in some circumstances, it's just not feasible to do it right out of the gate, right when we're filing the domain name. Honestly, Anthony, because in my entrepreneurship journey across the years, I have probably bought multiple hundreds of domain names, and I didn't know literally like which one was going to take off. Like, which one do I have the internal fortitude to work on? Which one am I really, really passionate about? And which ones are just kind of a hobbypreneur thing where I'm just kind of collecting and sitting on, and I have an idea for stuff I want to do, but I'm not actively doing it. Okay, so I understand. Okay, so maybe it doesn't make sense for every single domain name that we purchase to go out and do this trademark search. But okay, now we're getting serious about it. Like, now we're building our thing, right? Now we're building the Hello Tech Pros brand. We're doing a 7-day-a-week podcast. We put a lot of time and effort into this. We've got social media presence. We've got a lot of things going on. We're starting to get, advertisements in and whatnot. Now's probably the time for this particular brand, right, for us to go out and do some trademark search on, because it is like, I'm taking it seriously. This isn't just a hobby thing anymore. This is my company. This is my brand, and I need to protect it.
I hear you well. I mean, I would say if I would say this: if you and when I say you in general, obviously in a public forum like this, I'm ethically not allowed to give legal advice. But what I would say is, if what you are building is something that you expect money to come in, that's when the light bulb needs to go off, and you need to at least speak to an attorney. Even if it's something that you put off for a while, and again, you run the risk of what happened to the client that I described, but you should at least speak to somebody to talk about that process and to identify what the trademarks are in the business and to figure out what it would take to do the search, get an opinion letter, and if you're allowed to file, go file. That's it. You're going to need to do that as soon as possible if you're really expecting to make money.
Gotcha. Cool. Okay. So if the average Joe, if the average listener out there is in this position where they're thinking about whether or not they should, it sounds like they should at least have the conversation with the IP attorney and then make the decision from there on what they should do. Absolutely. Okay. Cool. Gotcha.
You should never feel pushed by and you should feel comfortable with your lawyer. You should never feel pushed by your lawyer. You should never feel as if you have to do something. I mean, if you're in litigation, you've got deadlines and there's stuff that you have to do. But like, you should in a consultation with an attorney, you should feel comfortable with that person, and you should feel as if that attorney has your best interests in mind. And when I say best interest, I don't mean taking a trademark and shoving it down come hell or high water, because if money is an issue, if time is an issue, if mental stress is an issue, then your attorney needs to take all of that into account and make sure that the advice is right. I've said to clients plenty of times, you've got a great, wonderful case here. You ready to fight for it? If you're not ready to fight for it, maybe just finding something new is the better way to go. And so you just have to make sure that the attorney you speak to is somebody you are comfortable with.
Gotcha. Cool. That makes total sense. So we should do it early. We should have that consultation. We should get a feel for, is their personality going to match with our personality, and then make the decision that's right for us and right for our circumstance. So Anthony, in just a moment, I want to talk to you specifically about the intellectual property concerns on software, because I know there's a lot of software developers, a lot of entrepreneurs who are listening to this who come from the software development world, and they're building stuff, using a little bit of open source, a little bit of proprietary, a little bit of their own stuff, and stitching it all together and making a new product. So maybe we could talk about that in just a moment, but first we're going to take a quick break and thank our sponsors. Chad Bostic here, and I've got a very special announcement concerning next week. Next week is going to kick off my very first Signature Series week. That is one full week dedicated to a single course, a single topic, and that topic next week is career development, specifically my Career Hyperdrive course, how to get unstuck in your career and launch your career back into hyperspace. Now, we're going to have 7 full days of content, and what you're going to get out of it is motivation that you need to overcome your biggest career obstacles, productivity tips to help you crush it at work without killing your personal life, leadership training that will build your respect and influence across the organization without needing to move into the management tracks, a technology mastery blueprint that's going to guide you through the process of selecting the right technology for the right problem every time, social engineering hacks to break into the elite inner circles and get a seat at the adult table, entrepreneurship tactics that will raise your value and salary within your organization and increase your reputation and negotiation power to the marketplace, and the peace of mind to unplug from the job without anxiety or guilt. Now, if this sounds good to you, you do not want to miss any of the episodes next week. And you're going to want to sign up for the course, the online course, because You're going to get access to all of the takeaways and all of the homework sessions. There will be homework. You have to do the homework in order to get unstuck. You can't succeed just by listening. So go to hellotechpros.com/career to sign up for the free course and get access to all the content. Again, that's hellotechpros.com/career. Okay, we're back with Anthony Verna. Anthony is a lawyer and managing partner at Verna Law. He's got a computer science degree and his Juris Doctorate, and so he knows all about things code and all about things intellectual property. And that's where
I don't know if I know all things code. I mean, it's been a decade since I've coded.
He's a very humble man, but he knows more than he gives himself credit for. So he knows a lot about the business of writing code. How about that? A lot about the business of writing code and protecting the intellectual property, which is the code that is produced. And we've been talking to Anthony about how to protect your domain, how to protect your intellectual property, how to protect your trademarks. And that comes down really to, talk to a lawyer, talk to an attorney, as soon as it makes sense in your case, right? When you're thinking about, I want to make money from this, it's time to go out and talk to an attorney and just have some consultation and to see, first of all, does that attorney personality, does that match up with your personality, right? Do you feel hustled or do you feel protected, right? And then, take into advisement whatever advice that they give you, and make those decisions that's best for your particular case in your particular business. So Anthony, we were talking about, you've got history with computer science. At least you have a lot of friends that are software developers. You have been to school for software development. So you know the practice, right? You know what it is. Some of it is I'm going to take some code that's already existing, like in the open source world, or copy and paste some logic that I used in a prior project, and then I'm going to build my own stuff with it. When you're at a corporation and that corporation, like let's say you worked at whatever XYZ corporation and they already have like their repository of all their code, you can just branch and fork from anything that's already there and build off of that. And that's very easy. But when we're an entrepreneur and we're off on our own, there's so much stuff that's out there that's open source and not open source, and things that we have built in our past lives and things that we are now specifically building for our business. What are we legally allowed to use and put together to charge people for, right? Charge people for our products or our services, but we don't want to get in trouble from like copyright issues and stuff like that.
So you stated a principle of copyright law in the question that I'd like to start with, and that is, obviously, if you've created something, you're an author. And you are also the owner of that particular matter, because software falls under copyright law in the United States. And if you're at a company and you create something that falls under copyright law, so software, that is in furtherance of your employment because you're an employee, or maybe you're a business, maybe you're one of the partners, one of the shareholders of the company, that falls under what we call a work made for hire. And because you're an employee, it automatically belongs to the employer. In other non-employer employee relationships, we need a specific contract for that. So that part is simple. Getting into something that's a little more complex, because yes, sometimes us as programmers, we go to message boards or we go to open source, whomever we go to. The issue there is not one of how much money are you charging for your product. The issue there is going to be, at the very least, maybe credit for a particular solution. It depends on what those solutions are pulled from. Like if you're pulling something that's open source, most likely in the final product, some credit will have to be given to some open source code from X. and it's open source, so anybody can use it, and no money is going to be charged one way or the other for it. But that doesn't necessarily mean that the end users get necessarily getting a discount on on the product. Mm-hmm. If that makes any sense to you, Chad. What I would say is copyright law is about who's allowed to make copies, who's allowed to sell copies, who's allowed to perform copies, and if code is coming from another party, then you're going to have to be very careful that it's not a lot. And I don't necessarily know that I have a wonderful idea as to what not a lot is. I will say this, the Supreme Court doesn't necessarily know what not a lot is either. In source code, in open source issues, the open source license obviously controls. And the open source license is very explicit about the fact that nobody's receiving money for the use of what's open source. So that's not necessarily a concern. But if it comes from elsewhere, there should be some kind of agreement as to what kind of royalties are being paid and what kind of credit is given. Although the statute doesn't really deal with credit, that's kind of an overblown thing. But if I were the author of code and my code were to be implemented elsewhere, I'd like at least, I'd like a royalty and some kind of mention somewhere in the credits of the software. It's tricky because copyright law really is a case-by-case basis when you're talking about the creation of the product. Mm-hmm. And I don't know that I have any wonderful blanket advice because of that particular issue. And I would just say, if you're an employer and you're writing software, make sure that every employee is writing original code, or you have a way of monitoring what code is not original and making sure that you understand the agreements that come with those particular parts of your code.
Gotcha. So we, as freelancers or as entrepreneurs, we really should be doing all or as much original work as we possibly can, right? And whenever we are using someone else's license, using someone else's property, then follow the rules to their license, right? So if they say it's free to use, but you have to give credit, then you use it and you give credit. Or if it says you can use it for free purposes, but not for commercial purposes, okay, cool.
Then so we can't sell it.
Right, then we can't sell it. And so we have to really understand the language that's in those licenses for those different parts and pieces that we're using in our software, right? So yes. If we're building a mobile application and we want to sell it on the Apple iTunes store for 99 cents, it's only 99 cents. But if we use an open source free utility that makes that application work, right? Let's say it makes the menu bar flip up and mm-hmm. down or whatever, a little animation thing. And that animation thing says you are free to use this in free purposes, but not for commercial uses. That means we literally we either can't use it in our application or we can't charge money for our application.
And depending upon the words, you also wouldn't be allowed to sell advertising in your app either. So, yes, you really need to make sure that you understand the language of the license.
Gotcha. And so if we are the person who's actually trying to put some open source software out there, right? We have written some original software and we want to give it back to the community. There's hundreds of different types of licenses that we can choose from, right? There's MIT licenses, there's Mozilla licenses, there's the do whatever the frick you want licenses, there's like 20 different GNU licenses. Creative Commons. There's all these different things. How do we decide which one is right for our case?
I would say it depends on what your purpose is. And I don't mean to necessarily be vague. It's just that's it really does depend on your purpose. If your main goal is to make money off of it, then you really need to take a hard look at which of these licenses works for you and under what conditions, and how you would collect. One thing that, say, Creative Commons gets thoroughly misunderstood for is that that's one of those licenses that says it's free for you for any purpose except selling it. And, if your main goal is to, if your main goal is to make money, well, you're not going to make, you might be able to make money because maybe people will notice your code and use it, and then when they want to sell it, they have to come back to you. So maybe that's kind of how you do it. It's like your local drug dealer. Here it's free until you really need it. Every license is going to be different, and your purpose is what's going to matter. I mean, maybe just make it open source because you say, look, this is the work I can do, and then maybe if it's good enough, maybe other people will come to you for other needs, and in a way that open source code is like advertising for you. Right. Depends on how you would like to handle the situation.
I just think this is it's a very unique world that we live in now, and it's a very confusing world that we live in now because back in the day, it used to be I create a product, which means a physical thing, right? Even if it was media, that media had to be printed on something, right? You had to print it on a disc. You had to, you printed it in a book. You wrote it to a record, like a physical, 78 or 45 or whatever they called it, old school, vinyl records, right? But you had some sort of physical media. Now everything's bits and bytes and electronics, and it's easy, and you can make derivatives and copies and mashups and all kinds of stuff, which makes it a really awesome world that we live in, but also very, very confusing as far as, how do I make money off of this? Am I just advertising the fact that I can do this type of work, and I'm putting my advertisements out there for free, meaning I'm giving away some of my creative work for free in order to show that, yes, I can do this for you in the future, so please hire me? Or am I putting this stuff out there because I want people to pay me for the rights to use those kind of things, and then how can I ensure that they're actually going to pay me and not just make copies of it? So it's just very confusing.
I understand that it's confusing, and that's why I say every situation's a little different, and you kind of have to take each situation by itself. I'm not going to have wonderful advice in a situation like this because what you might want, what each listener might want, is different from what somebody else will want, and so those different solutions will need to be taken, at that time. So yeah, it is very confusing, and I understand that. But I think there are positives and negatives of each. I mean, on one hand, you will, if your code is good enough and you make it known so that people can find you to hire you for other work, then chances are you'll find that extra work. That said, I know people who have who have written software and did, I don't want to necessarily say a Creative Commons, but they did a license where it's free for whatever use you want, except for selling, and then you have to come and contact me. And, it's work that they've done, and then they get paid on a royalty basis. It's what Jeff Foxworthy used to call mailbox money. You're just it's stuff that here's your check. It comes in your mail, and you actually haven't done more work. On the same token, at some point, that code isn't good anymore, and you need to find something new as well. So there are positives and negatives to everything.
Yeah, it's. I guess this is why it's confusing, is because there's a lot of different options, and really you have to discover the best option for your situation. So, Anthony, if you could sum it up for us generically, since we can't talk about specifics for specific cases here on this show, do you have any final words of wisdom for our audience? And then share the best way that we can connect with you, and then we'll say goodbye.
Sure, Chad. I would say this, that I hope I didn't scare anybody away from entrepreneurship. I love being an entrepreneur. I love my clients who are entrepreneurs. I've got a client right now where I said, well, you can enter a licensing agreement in X and Y, and I think if you did that, your business would utterly explode. And and I love hearing those particular reactions. And there are lots of ways of being an entrepreneur, lots of ways of selling a product. So I don't want to scare anybody away from that. Yet, you also can't always just put your head down and plow through. I think it's helpful not just to have an IP attorney, but a tax attorney, a corporate attorney. I think, at the very least, just to pick up the phone and say, hi, here's what we're doing, and just say hi. Hopefully we're a part of the entrepreneur's team. And so before you go branding, before you go creating, before you create an advertisement, before you create a EULA, terms of conditions, privacy policies, I would say pick up the phone and speak to your IP attorney, because that's what we're here for. We're here to just hear about your business and talk about it, and just see if what you're doing is in the best interest of your business. And that would be my overall general advice. Before you brand, before you create, call and talk. Gotcha. That would be that's we're here to hear you.
And where can we call and talk to you if we wanted to talk to you?
Sure. My phone number is area code 914-908-6757 in the suburbs of New York, northern suburbs of New York City. You can reach me by email at anthony@vernalaw.com.
Anthony, thank you so much for joining me on Hello Tech Pros today. I really value this conversation because it's something that is very, very important to me as an entrepreneur, to us in the business of building intellectual property, right? No matter what we're doing in IT or in technology, it's very little to do with the actual stuff, the actual physical gear and hardware, and a lot to do with the processes and the education and the information and the content that we publish and the software that we create. And this is something that I think is not talked about as much as we need to in this industry. So thanks for coming on the show and talking to us about it.
Hey, Chad, thank you for having me. It's been a pleasure.
You bet. Tech Pros, if you are in this position, tell you what, let me, full disclaimer here. I am not an attorney and I know nothing about the law, okay? But this is some advice that my stepdad gave me a long time ago as he was finishing his law degree. If you are in the position where you think you might need an attorney, you're already too late. Be proactive and talk to them early rather than later, because those upfront fees or those upfront consultations could potentially, depending on your circumstance, save you a ton of money in going to court and doing that stuff. And that stuff is no fun at all. Not fun at all. So if you think you might need one, go ahead and do some research, find out. And also, on this licensing stuff, I try to read this. And the problem with me trying to research and figure out the right license and what these licenses mean and kind of I use them is a lot like me doing research on WebMD, right? Everything is either I'm perfectly fine and again, this is I'm not a doctor, so I'm not giving out health advice, so I don't advise you to do this either. But when I do my own health and safety research on WebMD, I discover that either I'm a superhero and I'm immune to everything, and I need to buy a costume and go out and do superhero role play on the nights and weekends instead of entrepreneurship, or that I'm going to die tonight and I need to put my will in order. So in that case, I should probably not be doing any research on a WebMD. I should be going talk to a doctor. Go talk to a doctor. Go talk to an attorney. Go talk to professionals who know what they're trained to do and are experts in their field, people that you're comfortable with. You've been listening to Anthony Verna, and I'm Chad Bostic. And until next time, take care. The show notes page for this episode can be found at hellotechpros.com/181. Do you use Slack for team communication? Join the Hello Tech Pros Slack channel at hellotechpros.com/Slack. If you enjoyed this episode, please leave a review, subscribe to this channel, and check back tomorrow. This has been Entrepreneurship Saturday, but tomorrow my featured guest and I will not be talking about work because it's Sunday being unplugged. On Monday, we'll get motivated once again to face the week with Motivation Monday, followed by Tuesday, productivity, Wednesday, leadership, Thursday, technology, Friday, people communication, and Saturday, back to our entrepreneurship. And I'll talk to you tomorrow.